Has Bill Fletcher ever attempted to extort you or your family?
I don't answer that, Marcus.
As long as we don't get into any communications with Mr. Fletcher, if it's a simple opinion question, then I think that's on the edge, but that's probably allowable.
In my opinion, I thought he did.
Why did you believe that?
This is what it sounded like.
What led you to conclude that Bill Fletcher was attempting to extort you?
Objection on the basis that's already been explained. We're not going to get into that. That'll be subject to our motion filed with the court to explain the basis and foundation for asserting that privilege under Rule 26. So don't answer that.
I'm trying to cure my question. So help me understand how a statement of extortion, which would be actionable and illegal, I suppose, would be covered under a non-testifying consulting expert privilege. If I'm to assume Bill Fletcher is both the consulting expert and the extortioner, are you saying that that statement is privileged?
Been very clear that any communications with Bill Fletcher or anyone else that the company may have hired as a consulting expert are protected. We're going to explain to the court the factual basis so that he can understand what happened and why, and whether this privilege is protecting testimony about that you're going toward. And you've asked him his opinion about extortion, and he shared that with you, and then you were going further about why you believe that. That is inevitably going to get into the discussions at issue that we think are clearly within the protection, so that's where we're cutting that off.
I heard a lot of words but no answers.
We're not going to answer any more questions about communications with Bill Fletcher, why the company may or may not have believed that litigation was a possibility, who they may have hired as an expert under Rule 26, and all of those communications. That's all protected, and we're going to roll that into a filing with the court to explain the basis of our objection, and we're going to do that ex parte so that the judge can, or in camera, so that the judge can make a ruling and tell us whether this was a legitimate objection to this line of questioning. Not sure how else to explain it.
Did someone ask you for $2 million at some point during the pendency of these criminal charges?
Marcus?
Object to the form of the question. You can answer yes or no.
Yes.
Did they ask you for $2 million to build a hospital?
No.
Was it to build a high school gymnasium?
No.
How about a distribution center?
No.
It didn't have to do with D.F. Chase doing building work for anyone, did it?
No.
Was it a charitable contribution to PETA?
No.
Was it a charitable contribution at all?
No.
Was it a payment to Virgin Hotel Project investors?
No.
Was it a payment to a vendor or a builder?
No.
Was it a payment for legitimate work?
No.
Was it a payment for illegitimate work?
I don't know.
What were you to receive for $2 million?
Object to the form of the question. Don't answer that.
I'm confused. When you say object to the form of the question and then instruct him not to answer, Do you really mean to assert a privilege?
I'm asserting the privilege that we've already discussed. Bad habit. It's so easy to say object to the former question.
And I understand, but I would appreciate if you would make the objection that you appear to intend to be making, just so we have the record that we can show the judge.
If you're confused, I'll take responsibility. But we're asserting an objection about the who's, why's, what's on, to the extent we've already explained our position, and that will be taken up with the judge.
I'm going to ask the same question, and I fully anticipate for you to make the same instruction. It's not
Sure.
to be obnoxious, it's just to
understand.
have it clear on the record.
Got it.
Listen to your attorney's instruction. I think he's going to tell you not to answer, and I'm not trying to trick anyone. When this mystery person asked you for $2 million, what were you to receive in exchange for the $2 million?
Objection. Don't answer. For the reasons we've explained over and over, we're going to take this up with the court. Thank you.
Have you paid anyone $2 million in the last year?
No. Oh, for what? Work?
No. Have you paid anyone $2 million for anything other than legitimate work or a charitable contribution?
No.
When you received the request for $2 million that you told me about, was it to do something for you or to do something for someone else?
Object the form of the question. I apologize. Object, privilege, don't answer. Same reasons we've asserted. It'll be covered by our motion.
Did you believe that the $2 million request was to pay a bribe to someone?
Object, don't answer. It's covered by our prior objection. This will be addressed with the court in a motion.
You think that denying that he was asked money for a bribe is privileged? Because all he really has to say is no, and then that wouldn't.
You've already asked the question about whether he was asked for $2 million. He's answered that yes. I think beyond that, Brian, we're getting into, obviously, we're dancing around this subject that I think the judge will agree with us falls within the scope of Rule 26's privilege.
And I just want to be clear. When a lawyer makes a legitimate privilege assertion, I don't dance around it. You're making a totally illegitimate privilege assertion, and again, I want to be clear for the record. I'm allowing you to get your instructions, and he's not answering. But I do want to paint how broadly this supposed privilege is so that the judge gets a full picture of it.
I hope the judge has.